instructions are to withdraw the application and to tender costs. My instructions are further not to oppose any costs on the scale, the scale of the costs, and we abide the decision of this Honourable Court in relation to those costs.
When you talk scale, can you just clarify what you mean?
The punitiveness of the cost order. We are not opposing that.
You're not opposing that?
Yeah, we have no instructions to oppose that order.
Well, let's take 2 steps back. Your instructions are to withdraw the application in its entirety. Your instructions are to tender costs and to... Yeah.
My instructions are, I have no instructions to argue on costs.
To argue costs, okay.
Yes.
But you tender in cost in line with your withdrawal?
In light of the withdrawal, yes.
Okay. Thank you very much. Thanks, Advocate Black. Sorry, just before you sit.
Just to recap, is there a formal application for punitive costs before us?
There isn't a formal that I know of. I know they've mentioned it in a reply. In the replying affidavits, they've mentioned it, but that I haven't seen any notice of motion requiring.
And before you sit down, this matter was brought by the President in his position as President of the Republic of South Africa.
That's correct.
Thank you very much, Mr.
My Lords, I have a very brief submission on behalf of the Public Protector on the issue of costs. It's clear that the Public Protector is entitled to be included in the tender of costs up to the date on which the Public Protector withdrew her notice to oppose and filed a notice to abide. And I just wish to submit that it would be appropriate in this matter that the Public Protector also be granted its costs in respect of the events subsequent to the filing of a notice to abide. The Public Protector came to court in order to assist the court. It filed affidavits and heads of argument in order to assist the court, and it would not have had to have done so unless the application was brought. And I submit that it would be appropriate for the Public Protector to be included in the whole of the costs order, as well as that up until the date on which she withdrew her opposition.
Thank you very much. For the DA?
May it please the Court. My Lords, as far as the DA's position is concerned, Grade 2 of the Notice of Motion in the application for intervention is for an order directing the Public Protector to publish the final and signed report into the complaint laid by the Democratic Alliance on 18 March 2016. We move for such an order on the basis that there is no opposition. My Lords, on the issue of costs, our submission is merely the following, and that is that the entire backdrop of this matter relates to the use of state resources for private interests.
I see flash photography. Can I ask anyone who's inclined to do that and who's doing that to stop it, please? Thank you very much. Sorry, Advocate Labuskaghni.
As the Court pleases. My Lords, just a few submissions on the issue of costs. The topic of the surrender of control of state resources to private interests has been a recurring topic in the recent political discourse, and it forms the backdrop of the complaint that the DA laid. The submission is made even in this matter that the President has brought this application in his position, in his role as President, but he asserts a personal right. And in fact, if I could just read from his affidavit, the supplementary, his position, it's at paragraph 27, page 58, he says, therefore, as it's in the application for postponement and amendment.
Yes.
That supplementary affidavit that the President sought to adduce. He says there, as much as public interest requires that the report be finalized and made public, this cannot outweigh my right to enforce a constitutional right to just administrative action. Our submission is that it is clear that the President is asserting a personal interest and a personal right and is using the office of the President to do so and is using the State Attorney to advance that interest. And to withdraw the application without any consequence for the President personally, we submit, would not be appropriate. And our submission before the court is merely that the state coffers should not again be mulcted for private interests. And for that reason, the President should pay his own costs. And he should pay the costs of the State Attorney as well and his counsel from his own resources, my Lord. And that's the only submission. The issue of the scale of those costs we leave to the court.
Mr. Rabiscaffery, in the prayers on which you came to court, is there a prayer for the kind of remedy you are now asking for?
My Lord, what we are saying in our opposition is that the application constitutes an abuse, and that is the basis on which the court would grant a punitive cost order. My Lords, as far as the final paragraph of our application to intervene is concerned, paragraph 28, we move that the DA says that it requests that the application be dismissed with costs to be paid personally by the Minister, and we submit that the same arguments apply as far as the President is concerned. There are certain personal interests, and the abuse which we submit forms the backdrop of the application as a basis on which the court should show its disdain for the use of state resources for private interests. We leave that issue and the scale in the court's hands for decision, and those are our submissions. We move for the order for the report of the Public Protector to be released forthwith, as the court releases.
I follow your argument about the President also asserting a personal right. The whole backdrop of this matter, as you say, the alleged surrender of state resources and the alleged abdication of his responsibility relating to the appointment of ministers, all those talk to his position as president of the country, isn't it?
That is so.
What then, if that's the whole backdrop of the matter, would be the basis for ordering him to pay these costs personally?
My Lords, we've indicated that our submission is that because the President has used his official office to assert a private right and has used state resources to do so, the court should see through that aspect and treat him as the individual who seeks to assert his personal rights, and he should bear those costs and the state should not. As the court
Thank you very much, Advocate Labuschagne.
As a court, please, for the first intervening party.
Is that for the EFF?
For the EFF. Lord, before we accept what the President has offered or has tendered, and we want to draw the court's attention firstly to the fact that there is a counter application by the intervening parties, and their lordships will find that in bundle 1 to the main application, in which the last page was 33, and your lordships will find that order number 3 that is sought from this court is one that orders the first respondent, which is the President, to publish the report on the 14th of October.
What page are you on?
On page 2 of the notice of motion.
And is that the President's notice of motion?
In our notice of motion, my Lord, in the counter application.
What's the index page?
The index page, your lordships will find that our notice of motion in the notice of intervention and counter application is page 2.
There could be a problem of
Page 91, probably.
of pagination which is detaining us here.
But it is the counter application, Lord, as we have been talking about.
Well, we have an index here. And we are talking about index pages. You're talking probably about
there is
type
an
page.
index to first, second, and third intervening parties' application to
Is that what
intervene.
we're talking about? So it's not the main
Bundle
application.
1.
The intervening parties' applications.
Yes. Yes, my Lord.
Okay, I'm told.
And your Lordships will find...
Just bear with us. Application for postponement. Intervening party. Have you found it, JP?
This is. You say you're on page 2 of your index, isn't it?
Yes, my Lord.
Okay, which prayer are you talking about there?
We're talking about the prayer 3, in which we ask this Honorable Court to order the first respondent to publish the report.
Right.
The dates will obviously change
Yes.
because of where we are,
Yes.
and we need to disclose to this court that there is another process where we had asked that the date should not be later than the 8th of November because we had anticipated that we might probably be dealing with issues. But what is important in terms of that order and in terms of the fact that it is not being opposed is the fact that we are asking the release of the report forthwith, in which event we put a full stop there, and you are asking for the grant of this court's honorable order in terms of paragraph 3 as amended.
And the amendment is forthwith.
And the amendment is forthwith. Yes. The date should be removed from the order that will be asked for by first intervening part. So, my Lord, that is the first order of business. And this is so because this application is not being opposed. And there's a tender on the question of course. We had asked in paragraph 4 of that notice of motion that in the event of opposition, the order of course should be on an attorney and client scale. So we are not asking for anything that was not contemplated in the notice of motion. But further than that, and I will take your lordships to where we in the affidavit deal with the question of course, but where it talks to the question of scale, the President should have been aware that we are asking for course on the higher scale, and there is no opposition. There's been no opposition, in fact, to the counter application at all. They have not engaged what we asked for in the notice of motion, but further than that, they have not engaged us on the question of scale. So it's not a question of, whilst of course the question of course is always in the judicial exercise of their discretion by the court. In this case, a judicial exercise of their discretion we are submitting would be for the court to say there was notice to the President that the cost that would be asked for would be on the higher scale, and they have not opposed that prayer for cost on that scale. And we therefore submit with great respect, my lordships, that that is the scale unequivocally on which the court, in the judicious exercise of their discretion, should order costs against the President.
Attorney and client.
On an attorney and client scale.
Okay.
Now, the further point, my Lord, is captured, to use a no pun intended, in the preliminary point which the first intervening party raises about the utilization of State Attorney's Office on behalf of the First President. And that's a question that seeks to answer, firstly, the question that were posed, the questions that were posed to my learned colleague for the DA by the bench. And in the paragraphs 12, 13 to 17, the first intervening, it would be page 10, following page 2, where we had drawn the court's attention to what we were praying for. And it is important that we record that this is not something that we are asking for now.
When you say page 10, because you're using a different index, are you saying page 10 of that index or a different page 10?
It's page, in fact, it starts on page 9 of our intervention application.
The preliminary point.
The preliminary.
Okay, we've got it.
Yes, and it's paragraph
12.
Paragraphs 12
Yeah.
Yes.
to 17. And His Lordships will see there that we raise the point pertinently. The intervening parties take issue with the utilization of the state attorney's offices on behalf of the second respondent. The second respondent is alleged to have acted in concert with the Gupta family in an irregular and corrupt manner in his personal capacity, and most certainly not in his official capacity as the President of South Africa. Consequently, the second respondent ought to have enlisted the services of private attorneys, as was done by the applicant. This has obvious cost implications. We raise it pertinently and we say on paragraph 14, there is no basis in law or fact to settle the taxpayer with the costs incurred in this application. Plainly put, the taxpayer's interests are both served by the respondent's report being released forthwith, and it cannot be said that the relief sought by the second respondent is in the public interest or ought to be funded by the taxpayer. The time has come for the second respondent to accept personal responsibility for the costs incurred in the multiplicity of actions which he is currently involved and has been for the past decade. This submission relates specifically to the current, and then it goes on to talk about other things. And therefore it says, the second respondent ought therefore to be liable for costs incurred in this matter in his personal capacity, as if he had employed private attorneys as opposed to utilizing state resources by virtue of the position that he holds as President of South Africa. In other words, my Lord, the submission here is that the President may have chosen to ride two horses, but as your Lordships know, there comes a time when the bench or the courts will say in corporate law that we must pierce this corporate veil. And I think this is the time for this court to say, yeah, we see that the President may well be hiding behind the fact that he's President. But actually, it is clear that he is doing all these maneuvers in his personal capacity. And therefore, to the extent that he didn't oppose a challenge that the first intervening and the other parties posed captured in these paragraphs of the founding affidavit, to that extent, the President must be accepted by this court to accept that even though he would be opposing this application if he were, and in his capacity as President, what is clear is that he is serving personal interests. And to that extent, and to the extent that he has opposed, in a clear and undisguised way to serve his own personal interests, to that extent, this court should be at large to order that the cost must be paid by him in his personal capacity.
Advocate Msebenza, the President has withdrawn the application and has tendered costs. You are inviting us. Should we interpret that to be an invitation for us to go into the merits of the matter?
My Lord, he has withdrawn an application which is other than this application.
Yes.
This is a counter application where the presidency and the president himself have not offered any opposition.
Right.
And therefore, we are saying, insofar as we move
Yes.
for this court to give us an order in terms of this counter application, which is unopposed,
Yeah.
then the president must be presumed to have considered that everything that we pray for is something that is not opposed by him and it.
Sabesa, I've been looking at, I've had sight of the paragraphs you referred to. In your notice of motion, however, you're not calling for the president to pay personally. You're just asking for attorney-client costs in the notice.
My Lord, yes.
Here
It
you're
is.
saying you're inviting the court to use your expression to pierce the corporate scale. Now, having regard to how your notice of motion reads, was the president ever at risk of paying costs personally? Did you put him at that risk?
My Lord, other than to say it is a matter that the court, again in the judicial exercise of its discretion, might consider under paragraph 6 of the notice of motion further alternative relief. That is our submission as far as that goes. Especially because in the affidavit we have canvassed the issue and it remains unopposed. My Lord, again, in the judicial exercise of its discretion, I think, and what I think is what I submit, this is a matter really in relation to which this court should look back on the last 48 hours of this litigation and say to itself, the number one citizen of this country has been involved in a manifest abuse of this court process. And I can say this court in October ordered that all the parties must file heads of argument by a particular date. All the parties complied with a court order, except the president. The president did not file heads of argument in the application. And I'm tempted to say, I'm not surprised that they now are capitulating because they never applied themselves to their minds to what the court had ordered. The court had ordered heads of argument on their main application. Heads of argument on the counter application by the intervening parties. Now they come with an amended notice of motion in which they claim all manner of things, but that has been withdrawn. But to the extent that the court is aware of what they were coming with, they don't have time, they need time to do this, that, and the next thing. If they only had complied with the court order and the directives, if they spent all that time in making sure that they have answered to management work, that they have done all the things that the court has said must be done by a particular date, then we would have a sympathetic submission to make with regards to question of cost. No, they didn't do that. They had time to draft comprehensive heads of argument, time to make a comprehensive application for a postponement, which was abandoned all of a sudden. And the court must say to itself, in aid of what? In aid of what are all these maneuvers done? In fact, there was a presumptuousness on their part by filing heads only on the postponement application and not filing heads in the main application. It was a presumptuousness that was informed by its desire to be dilatory and waste this court's time. And had it not been for the firm case management of these proceedings by the court, they probably would have gone away with it. But we are here now in a situation where an application on all jurisprudence was stillborn. And I don't want to go into the merits, but in so far as I'm addressing the question of cost and why we want to persuade this court to grant costs not only on the higher scale, but to the extent that we have articulated, those costs to be borne by the president himself. We need to indicate that this was a stillborn application, both on their own notice of motion and for failing to reply to our counter application, but more so, in the failure for them to answer questions that this court would have had. Because the directives of the court were very clear. Even if it is so that you won't have time to deal with the main application as you claim, but please, can we have an answering affidavit? Can you answer Menchi Mentor? And it never happened. So we are making this submission, Lord, because we want to impress upon the court that whereas courts are totally in the discretion of the court, and the test is whether there has been a judicious exercise of their discretion by the courts, we now have indicated that opposition to this application, certainly to the counter application for which I have now moved an order, was stillborn. Now, with regard to the main application, my Lord, that also has been withdrawn. And your lordships have read all our heads of argument. And again, to the extent that we seek to persuade their lordships that this is not an application that should have been brought in the first place, we ought to say, in dealing with the merits of the application, that this court was being accosted to endorse something which the statute and the Constitution enjoin this court to do. The Constitution in Section 1 talks about our democracy being a multi-party democracy, founded on the foundational values, one of which is transparency. The Constitution, Section 7, binds the courts to preserve, to protect entrenched rights in Chapter 2 of the Bill of Rights. And Section 32 is one such right, the right to know. Now, you are being asked by the President, the #1 citizen in the country, the one who signed the Public Protector Act into existence, the one who is enjoined by the presidency, by the Constitution, to protect all entrenched rights in the Constitution and any other rights you will submit. Now you are being asked not to implement a constitutional imperative and a legislative enactment. Now, when you take into account, therefore, all of these things, you should be persuaded to say, having gone through 2 weeks of reading papers, most of which were skirmishes on whether or not we should be postponing these proceedings or not, when the one issue, the only issue that was before his lordships, was whether or not you should comply with an enactment of Parliament which was signed by the President and with the injunctions of the Constitution. Then you must say, when after it all, when we had even prepared ourselves to hear what the arguments are going to be, when we had even considered the jurisprudence about whether a cry for failure to give a person procedural rights can in and of itself trump the exercise or the implementation of a legislative and a constitutional imperative. Constitution from Ode Kral and all the other cases that have been quoted by all the opposition lawyers in their heads of argument should have informed the president that this is a stillborn. It can't be won on any terms. On that basis, my lord, I think we have traversed enough of the merits to inform your lordship's decision as to whether costs should be granted not only on the high scale, but to the extent that we have indicated, lordship, also against the president in his personal capacity.
Thank you, Mr. President.
Those
Thank you.
are submissions.
Thank you. Advocate Mpofu, are you going to advance submissions on the issue of costs?
Yes, hello.
And can I request that you don't traverse ground that has already been traversed?
A request accepted. JP. If you may allow me just to preface the extent to which I
Just before you continue, I see the continued use of flash photography here. It's not good for the eyes. We're trying to read things here.
But anyway, we have stopped it.
No, it happened, no.
But besides whether it's good for the eyes or not, there's been an injunction.
I hope it doesn't happen again.
as the court pleases. My lord, if I may, I'm really doing three things. One is to on behalf of COPE and the UDM, to move for the counter application in terms of that our prayer 3 as amended. In other words, the amendment is simply to remove any reference to dates, because the word forthwith is already there. Then, my lord, and that's obviously on the basis that that application is unopposed by any party. So put that aside. Then on the question of costs, my lord, I will associate myself with what my learned colleague, Mr. Ntsabeza, has said. In other words, I'm moving for both the question of scale and the question of whether the courts should attach personally to the person of the president.
Yes.
On the question of the, well, let me just preface my remarks by saying, on both of those legs, I have to emphasize that these are unopposed applications, both on the question of the scale and on the question of the personal attachments of the costs. And to that extent, I would assume, subject to guidance from the bench, that the question of the scale of the costs, which was prayed for, and there's no doubt about that, notice was given and it still remains unopposed, is a matter that I don't need to spend a lot of time on, to the extent that it's not opposed. Obviously, I still have a duty to guide the court because the court has a residual discretion.
But You shouldn't assume that we have made any decision at this stage.
Without assuming anything. In fact, the reason why I'm doing this is try and save time, because in the submissions that I'm going to make in regard to the personal attachment of the costs, it will ipso facto deal with the question of the scale of costs. The conduct, the usual standard, which is the conduct and behavior of the litigant, except for the additional leg that we are introducing now. My Lord, yes. I would like to start by reading out an extract in the case of Solidarity and Others versus SABC 2016 bracket 6 SA CC SA 73, sorry, CC LC in the Labour Court, 2016 bracket 6 SA 73 bracket LC, paras 77 to 78. And it deals with the basis upon which this submission is going to be made, but also somewhere there is foreshadowed the question that the Deputy Charge President Mojapelo correctly asked regarding the prayers. Obviously deals with the effects of that case. It was about an MEC. However, that does not excuse their behavior. It says, okay, let me read it all. In the present case, the best that can be said for the MEC and head department is that their conduct, although veering towards thwarting the relief sought by the board, cannot conclusively be said to constitute contempt of court. However, that does not excuse their behavior. The MEC, in her responses to the opposition by the board, appeared indignant and played the victim. She adopted this attitude while acting in flagrant disregard of constitutional norms. She attempted to turn turpitude into rectitude. The special cost order, namely on the attaining client scale sought by the board and Mafujane, is justified. However, it is the taxpayer who ultimately will meet those costs. It is time for courts to seriously consider holding officials who behave in the high-handed manner described above personally liable for costs incurred. This might have a sobering effect on truant public office bearers. Regrettably, in the present case, it was not prayed for and thus not addressed. That's the Deputy Charge President's point. Paragraph 78, it says, I am satisfied that there is no question that the applicants should not bear the cost of bringing this application, including the cost of two counsel. I'm also concerned that the dismissals were authorized and reckless. Anyway, it deals with the facts of that case. Paragraph 78 is not directly applicable. I'd like us to put an imaginary finger on that proposition. And maybe I should, before I do that, address the point raised by the Deputy Charge President. With the greatest respect, Deputy Charge President and the court, I would submit that although technically speaking, the prayer that the Deputy Charge President points to does not deal with this question of personal attachment and is confined to the question of scale, which I have to concede because that's what it is in black and white, that this case is distinguishable on that aspect from the gambling board case for the following reasons. One, and the most important of those reasons, is that the paragraphs is that the first, second to the third intervening parties foreshadowed and notified the president. Might not have been in the conventional manner, but if we think about, we can't elevate form over substance, as it were. The point of the matter is that they were made aware that this point is going to be raised. And it did more than simply just putting it in the prayer. We went on for 5 or 6 paragraphs. And in greater detail, once again, I don't want to repeat what my learned colleague has read. But in detail, we say, and that comes to the point that the Judge President has raised. We say, although at face value, and again we have to consider that, at face value, what we have here is the president of a country, qua president, being accused of doing certain things in respect of that office specifically. But if we just scratch the surface with the greatest respect, it will become clear that all the activities that are in all the papers that are here really deal with the personal interests and personal benefits of the president. They deal with serious allegations of corruption and nepotism, of ensuring that the financial interests, his personal financial interests, we know the allegations about the involvement of his son and all that. Those cannot, by any stretch of the imagination, be ascribable to the office of the president per se. None of the powers that are ascribed to the president in the Constitution include putting your son with some business interest and as a proxy for your own business interest. None. So what we really have here, and if I may make this example, for example, it's relevant just to the point I'm making. Let's take Minister Zwane's issues, Minister Van Rooyen's issues that we debated yesterday. There's the talk of the so-called frequent visits. Those frequent visits, on all accounts, happened before he was appointed as minister. So can he now come here and say, well, I'm now a minister, therefore I can use the state attorney, even though those activities were obviously committed in his personal capacity as a private citizen? He can't.
It's an unfortunate comparison.
Well,
because the kind of order you're seeking against the president, you didn't seek against Mr. Van Rooyen.
Well, for one reason and one reason only. And in fact, that is explained very clearly in...
I'm told that he came here in personal capacity and bore his own cost.
And we actually say so in the affidavit.
So you can disregard that.
Yes. In the... as a court business, my lord. In the affidavit, well, it's not even that simple. Your lordship might be correct. In the affidavit, we said the president should have used private attorneys just like Mr. Van Rooyen. In other words, we used Mr. Van Rooyen as a shining example of what we were saying should be done. And we were praising him. Well, I'm sorry, we have to withdraw that praise.
Because you need it now for your argument.
No, because what happened is that yesterday we received the application of Minister Zwane. And it turns out that Minister Zwane is also using the same attorneys as Minister Van Rooyen. So this might not be as praiseworthy, that conduct, as we thought it was. But let's put that aside. The issue is simple here. When we were making that comparison, we were saying, well, we thought at least Minister Van Rooyen must have realized that these kinds of allegations cannot be ascribed to the ministerial office and therefore went to private attorneys. And we're saying the president should have done exactly the same. Now, the issue is quite simply this. If these activities can be attributed to the office of the president correctly defined, then obviously he's entitled to be represented by the state attorney. More so, again, a point in his favor. When the complaint was laid, And even when the letters were written by the public protector, they were addressed to him in his official capacity. We concede all that. However, as my learned colleague Mr. Ntsebeza said, we propose that in line with the warning that was given in the Gambling Board case, the time has come for the court to scratch the surface and not just look at what is apparently in front of us.
The Gambling Board case, the Gambling Board case, that's the one you read.
That's the one I read.
And the point made there was that that relief was not sought. Had it been sought, it would have been granted.
No, as I said, Judge President, both the concerns of that he came as president, which was raised by yourself, and the concern raised by the Deputy Judge President that it was not in the prayer, I'm going to address. I was just starting with your...
No, I wanted to check whether you have other authority that is in point. That leads us where you want us to go.
Well, then maybe let me move to that point quickly. The point I'm making is simply this, Honorable Judge President, that case is distinguishable on the point. And my argument is simply the question of substance over form. I'm saying in this case, notification, because the reason of putting something in a prayer is notification of the other party. So that, as the Deputy Judge President was saying, they must know that they are at risk of something. There's no debate about that. I'm saying that that has happened in substance here because we have gone even more than just putting a prayer. We've gone to town to tabulate in detail why it is that the cost should attach personnel. But what is more is that those paragraphs that deal with in detail with why the cost should be attached personally have not been responded to by the President. So we did more than just putting it in a prayer. We elaborated on it. All that would have done is if the President thought this is nonsense and I don't understand this, is to say, no, you're making a mistake. Blah, 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 here for this and that. He doesn't do that. So the notification plus elaboration remains unchallenged. And it can only be unchallenged because he must know. Well, the general rule is that if you don't dispute allegations, then you admit them. Then he must be admitting that he was acting for his own nefarious personal purposes. And even just at the level of common sense, with the greatest respect, let's now look at what the conduct for both points. And before we look at the conduct, we must look at the fact that this president in particular has been warned about this. This behavior of frustrating the work of the public protector is not something that has started with this matter. And that is why that expression that the time might well have come for the courts to say something about this. And our clients feel very, very strongly that that time is now. This is what was said in the case of economic freedom fighters versus the Speaker of the National Assembly and others, which is colloquially known as the Gandla case. At paragraph 54, the execution of her investigative, reporting, underline, or remedial powers, rather in the execution of her investigative, reporting, or remedial powers, she, the public protector, is not to be inhibited, undermined, or sabotaged. And I jump one sentence.
Why do you like jumping sentences? We want to hear the whole.
I can read the irrelevant stuff as well. Okay.
Look, if it's a
I'll read it. Yeah.
Yes.
I jumped the sentence obviously because it pertains to the facts of that case, but I'll read it if the court insists. I'll read the whole thing. When all other essential requirements for the proper exercise of her power met, she is also to take appropriate remedial action, which is obviously relevant here. Our constitutional democracy can only be truly strengthened when there is zero tolerance for the culture of impunity. The prospects of good governance are duly enhanced by enforced accountability, the observance of the rule of law, the respect of every aspect of our Constitution as the supreme law of the Republic are here. Within the context of breathing life into the remedial powers of the Public Protector, she must have the resources and capacities necessary to effectively execute her mandate so that she can indeed strengthen our constitutional democracy. Paragraph 55. Her investigative powers are not supposed to bow down to anybody, not even at the door of the highest chambers of raw state power. The predicament, though, is that mere allegation and investigation of improper or corrupt conduct against all, especially powerful public office bearers, are generally bound to attract a very unfriendly response. An unfavorable finding of unethical or corrupt conduct coupled with the remedial action will probably be strongly resisted in an attempt to repair or soften the inescapable reputational damage. It is unlikely that unpleasant findings and a biting remedial action would be really welcomed by those investigated. Now, the relevance of this is actually very profound, because this case, after all, is about what Chief Justice Mogoeng was talking about, which is attempt to repair or soften the inescapable reputational damage. In other words, this whole case is about saying, look, if the report is released, I might suffer some reputational damage. And this is what was foreshadowed here. The law cannot be used to shield the reputational damages of corrupt people. So the point I'm simply making is this. Let's take this as it was the first warning in the Nkandla case of the kind of behavior. And what have we seen here? We have seen an even more aggravated form of abuse of this court. We are all sitting here, full bench, and so many counsel, 2 days of the court's time. For what? We were told on the 24th of October, at the latest, all the political parties here sent a letter to the president. And we said, in the light of your concession contained in paragraph 81 of your answering affidavit, that if the report is final, then it must be released. That's what he said. We said, in the light of this, please withdraw the case before we even do our replying affidavits, so that we don't incur any more costs, so that this court does not constitute a full bench or all sorts of other arrangements. Please. This is the 24th. Ignored. On the 25th, the following day, we did the replying affidavit in which we repeated, and so did the DA, by the way, we repeated, the DA even went more elaborately to say there's no longer any live dispute. And we said, paragraph 81, you concede that if the report is final, and the public protector has now explained that it is final, then that's the end of this case. No, nothing. Only on Saturday, the 29th, 6 days later, we get what, at least in my estimation, with the greatest respect, amounts to the greatest insult to this court and to the collective intelligence of the South African people. The president says on the Saturday, no. That paragraph 81, it was a typing error. What actually wanted to say was, if the report is final, it should not be released. Now, that, with the greatest respect, is a criminal offense. It's perjury, it's a lie, it cannot be sustained. The DA and ourselves in our affidavits over the weekend in response to the application for postponement have elaborated on that. It's impossible that that was a typing error for two reasons. One, Because if it was a typing error, when we raised it on the Monday, the 24th, and said the case is over, they would have said, oh, it's a typing error. No, they don't do that. But more importantly, if you read, they forgot, this is what happens when you commit a criminal offense. You forget sometimes to cover the tracks. They forgot that there are other paragraphs in that very same affidavit. Paragraph 82 says that, however, in that event, the president will have recourse to review proceedings. I'm paraphrasing. In a separate paragraph, they say the irreparable harm will obviously not accrue. I think it's paragraph 95. Will not accrue if the report is final, as it looks like. They forgot to correct that one. And then in paragraph 97, then they say we accept that if the public protector was functus officio, then the report must be released. So it's nothing but a blatant lie, deliberately made under oath to pull the proverbial wool over the eyes of this court, and this being done under oath by no less than the president of a country, with the greatest respect, is something that deserves the judicial frown of the sternest order. And we say with the greatest respect, my lord, that kind of behavior, and I'm just picking one really, there's a litany of including the fact that we're told only this morning that the matter has been withdrawn, but I won't go there. There's a litany of that kind of conduct, but I'm simply singling out this one because it amounts to criminal behavior and impeachable behavior. Now, if I'm correct then that the president, at least it is arguable that some of these activities that he performed could not have conceivably been performed in his capacity as the president, but in his personal financial capacity or whatever else. If I'm also correct that the president has been notified sufficiently of the risk of a court order that attaches to him personally. If I'm also correct, 3, that the behavior is of such a serious and egregious manner and contemptible manner that the court should visit it with the requisite amounts of opprobrium. Then the only question that remains is whether this is not one of those cases that was being foreshadowed in the gambling board case. And if I'm correct, lastly, that the warning was sounded by no less than the Chief Justice about trying to frustrate and sabotage the actions of the public protector, with all the gymnastics that we've seen here of ministers coming and going and all sorts of things. With the greatest respect, my lords, I would implore this court to send a message out there before it is too late. I would implore, I'm sorry. Okay.
That whispering is just to check how long you still be. This is not an attempt to curtail you, just for us to manage our timetable.
Yes.
Yes.
Yes, I do realize that it's almost tea time. I'm not going to be much longer.
It's almost tea time, but if it meant that you had a few minutes to finish, we don't want a requirement such as that to do that. But if you're going to be long, it might not have to give you 2 minutes when you actually need 20.
Let's go. If the court can just indulge me with 5 minutes.
5 minutes.
Without
with that information at hand, we will confer again.
Oh, yes.
I think we're going to adjourn.
If I may indicate, my lords, that that's probably the right thing to do, because there's still counsel for Ms. Mentor, who wants a couple of minutes as well.
We realize that other people are going to argue. Thank you.
And we hope that no one will follow your example at overusing the airtime available. Thank you. Court adjourned.
All right.
Advocate Mpofu, you still on your feet?
I just want to make 2 or 3 quick points. The one is a broad point about the general cost to the public of all these shenanigans. And that includes the amounts that we refer to in our founding papers of 500 billion that was lost through the so-called Nene Gate, other 50 billion here and there. The amounts are not...
The cost you're talking about is cost in this action.
No, I'm not talking about... I'm not saying you must pay 500 billion. I'm saying the cost to the country.
The cost of this case?
Yes. In other words, the conduct. Oh, no, I'm talking about the conduct. The entire conduct around the Guptarization of South Africa.
Yeah, but our jurisdiction is to consider and decide the cost of this case.
Yes, but in considering and deciding the cost of this case, you have to look at the conduct of the litigant that we're talking about. Yes.
Their conduct in the case.
Yes, and in the case, what is the case about? The case is about allegations of abdication of power and appointment of ministers, such as happened in Nene Gate. Yes. So that's the context. In other words, everything that was done in the context of this case, to that extent, then becomes relevant. And the point I'm making is...
I am restraining myself, but I think as counsel, you should know what troubles me so that you focus on what I should decide on.
Yes.
I suspect that when you refer to Nene Gate, you refer to what happened in December last year.
That's correct.
Now, while the judiciary has its function to do, we only judge what comes before us.
Yes.
We cannot judge that which did not come again before us. And today what has been brought to us is an application to compel the public protector or to direct her to release the report, and the other one was to interdict. That is what we should really deal with. And the costs must be the costs which arises from the way the case was conducted.
Yes.
Not before that.
Well, if the court will then bear with me so that I can indicate where I am in the papers. If your Lordship goes to, if we confine ourselves to what is in the papers, to page 21 of the bundle, of our bundle. Your Lordship will see that the point I'm making is actually part of the papers. Paragraph 46. And I'll read it out. The conduct that is the subject of the first respondent's report, that's the public protector, the one in this case, is of both international and national concern. It caused a massive devaluation of our local currency and caused a loss of more than 500 billion rand on the value of the Johannesburg Stock Exchange, and when the second respondent appointed the applicant as the Minister of Finance for 4 days, that minister being Minister Van Rooyen. So the issue I'm raising is not, I'm not asking the court to take judicial notice or anything like that. It's in the papers, and it has not been refuted. As court pleases me. Now, the other issue which is also raised in the papers is the relationship of this pattern of behavior, but I've made that point in relation to the Nkandla issue when I said that was the first warning. All we want to raise now, my Lord, is the following. In closing.
In the Nkandla matter, I wasn't involved. We've read it. There was an issue of the upgrading or improvements benefiting the president personally. was there an order sought for him to pay the costs of that litigation personally?
No, there wasn't. I wasn't the case.
That's all I want to hear.
No, it wasn't. The personal cost in that case attached to the what your lordship has just called the so-called upgrades. Fortunately, I wasn't that matter. Yes. But the point we are making is that if you take that one as the first warning, this is the one that needs to.
Okay, sorry, I disturbed you. You were concluding.
Yes. I was saying, my lord, this debate about cost is for our clients a very, very serious matter, and one that we would like the court to pronounce upon. Accordingly, we would like to propose the following. If, and it's a big if the court, on the point that was raised by the DJP, is not convinced that sufficient notice has been given, then the court can do what was done in the SABC case that I read out, which was to then ask that litigant to show cause, to come back and show cause why the cost should not be personally attached to them. So that is if the court still feels that sufficient notice was not given. But the rider to that is that we would like to decouple that issue from the issue of the report. In other words, it would be competent for this honorable court to say we grant the order to release the report forthwith, which means immediately. It must be released, and then make an order similar to the order that was in the SABC case in relation to the notice, so that the person or persons involved could maybe show cause. That was an elegant solution which was adopted in the SABC case.
You mean in relation to costs?
Yes, in relation to personal costs.
Yes.
Remember, DJP, that your point was raised there that it had not been raised in the prayer. And for that reason, the person was then given a time to come back and show the court. But that did not stop the granting of the rest of the relief that was sought. So that could be a way out if the issue of notice is still of concern to the court. If not, if my submissions that the notice was in effect sufficiently given, then we would submit that the way would be open for the court to grant the order on the punitive scale and to attach personally to the recalcitrant litigant, as the court pleases.
Thank you, Advocate Lewis.
My lords, I'll be very brief on the issue of costs. We have, of course, taken note of the fact that the state has tended to pay the costs of all the respondents, which of course includes Ms. Mentor as a party who was granted leave to intervene. My lord, as to the issue of whether the president should be ordered to pay the costs in his personal capacity and on a punitive scale, if this was simply an issue that was to be addressed at the level of law, I would be aligning myself entirely with the submissions that have been made on behalf of my learned friends, particularly in relation to the fact that the president has sought to protect a personal right here by using state resources. And I would have relied, my lords, on his allegation in response to our application to intervene at paragraph 26 of his answering affidavit, in which he stated that the relief is aimed at ensuring that the public protector gives effect to my right to just administrative action. My lords, you'll also recall the submission that was made yesterday on behalf of the president, that this issue pertained only to the president's procedural rights and had nothing to do, in the president's view, with the public interest. And so, my lords, if the issue was to be dealt with at that level only, I would be aligning myself and asking for the same relief that my learned friends have requested. However, we did not, in our notice of motion or our affidavits, give any intention, give any indication of an intention to apply for costs on that scale. And so on that basis, I don't think that it would be appropriate to argue for that relief now.
Thank you very much. Advocate Lewis.
My lords, no submissions, just two references, if your lordships will permit me.
Yeah.
It's where the DA gave notice to the president of personal cost orders. The first is in the DA's application for intervention. It's in the letter that starts at page 98 where an offer was made to the President at that stage to agree to withdraw the application by consent, to authorize the report to be released with no costs, and at page 99 it is stated at paragraph 6, if your client refuses to consent to the order or a reasonable variation, our client will seek a punitive costs award against your client in his personal capacity. That's in the application for intervention. And then also, my lords, in the application for postponement and the notice of amendment, in the final paragraphs that are found in that application on page 116 to 117, the DA indicates that it would seek, in addition to the release of the report, an order that the President be pay the DA's costs on an attorney and client scale in his personal capacity, and also that the President be ordered to pay his own counsel's fees in his personal capacity. Those are the two references I just wish to bring to the Court's attention.
We're still sticking to our Thank you very much for all those submissions. Because council are on brief for the day, we thought we could give them work to do. And that work is to give us a draft order that deals with the withdrawal as well as the uncontested parts, that is the counter applications and the orders sought there. Leave out the issue of what was argued now, the personal liability of the costs.
Just for clarification, my lord, the uncontested parts, except for the issue that the court might consider separately.
That's why we want to adjourn and consider our thinking.
Consider the submission.
Whilst you prepare the draft order about the other
the
parts.
Uncontested parts. As a court pleases.
Advocate Teresa?
My Lord, may I just rise on the question of course against the President. Somebody has emailed to me or has sent to me a reference, George Marr, M-A-R-R, versus MEC for Health, Eastern Cape, and one other. Case number 3908/2005. It's a judgment of the South Eastern Cape Local Division. I have not seen the case, but I am told it would be a matter that addresses the whole question of costs against the President.
You have been fortified while you are in the battle.
Indeed.
Okay. Thank you very much. So please prepare the draft, give it to us whilst we consider our view to the personal liability of the President regarding costs. Thank you very much. I'll take this. Will you bring my bundle, please? It's this one. Not this one or that one. Thank you.
Daai sy soek dit hier. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Can you guys hear me? Is it okay? Yes, I can. Okay.